The States Supreme Court has the Justice Department's response to Donald Trump's appeal to the Supreme Court in the appropriately titled case of Donald J. Trump versus United States of America. The Justice Department used all of the 7 days granted by the Supreme Court to file its brief, which was due today. The 32-page brief signed by the Solicitor General appears to crush every point made by the Trump lawyers in their appeal to the Supreme Court. The Solicitor General's brief leans heavily on the unanimous opinion of a three-judge panel of the 11th Circuit Court of Appeals, which agreed completely with the Justice Department that the special master process imposed on the case by a judge appointed by Donald Trump should not in any way include the 100 or so documents marked classified that were found by the FBI with a search warrant served at Donald Trump's Florida residence. The Trump lawyers are now arguing that they agree with the appeals court that the Justice Department should be allowed to continue to use those classified documents in their criminal investigation, but that those documents should also be included in the special master process designed to sort out which of the documents, if any, are the property of Donald Trump and should be returned to him. Today, the Solicitor General said that those documents cannot possibly be returned to Donald Trump because he, quote, has no plausible claims of ownership or privilege in the documents bearing classification markings. The Solicitor General reminded the Supreme Court that the Supreme Court itself, quote, has emphasized courts should be cautious before insisting upon an examination of records whose disclosure would jeopardize national security, even by the judge alone in chambers. The Solicitor General told the Supreme Court that the appeals court has already fast-tracked this case for an early decision by the full appeals court, and that makes Donald Trump's emergency request to the Supreme Court unnecessary, especially since Donald Trump's lawyers have told the appeals court that the case does not require fast action and actually asked the appeals court to delay any argument at the appeals court level until next year. We have our team of legal experts ready to analyze today's Supreme Court filing, including Harvard constitutional law professor Lawrence Tribe, who says that the filing, quote, pulverizes all of Trump's arguments. The New York Times is reporting more details about the Trump lawyer who has a criminal defense lawyer of her own and is cooperating with the Justice Department investigation of Donald Trump. The New York Times reported today that attorney Christina Bobbs' first words were, "Wait a minute, I don't know you," when she was asked by another Trump lawyer to sign a certification saying that the Trump lawyers on June 3rd were then handing over all of the government documents that were then at Donald Trump's Florida residence at that time. The Times reports Ms. Bobb, a 39-year-old lawyer juggling amorphous roles in her new job, was being asked to take a step that neither Mr. Trump nor other members of the legal team were willing to take, so she looked before leaping. She later complained that she did not have a full grasp of what was going on around her when she signed the document, according to two people who have heard her account. The Times reports that another Trump lawyer, Evan Corcoran, summoned Ms. Bobb to Trump's residence on June 3rd and, quote, asked her to sign a statement for the department that the Trump legal team had conducted a diligent search of Mar-a-Lago and found only a few files that had not been returned to the government. Ms. Bobb met with Justice Department lawyers in Washington on Friday. The Times reports, quote, she told them that another Trump lawyer, Boris Epstein, contacted her the night before she signed the attestation and connected her with Mr. Corcoran. Ms. Bobb, who was living in Florida, was told that she needed to go to Mar-a-Lago the next day to deal with an unspecified legal matter for Mr. Trump. Mr. Corcoran, she told the Justice Department, had walked her through how he had conducted a search of a storage facility at Mar-a-Lago for the documents. She said she had believed at the time she signed the attestation in June that it was accurate according to a person with knowledge of the situation. Each of these legal twists and turns in the investigation of Donald Trump is bringing us ever closer to the day when the Attorney General of the United States, Merrick Garland, will have to make a decision that no Attorney General before him has ever faced. Will he approve an indictment of a former president of the United States? And today, as Alex and I were just discussing, in a new piece for the Atlantic Monthly, Franklin Foer, who has interviewed Merrick Garland and has studied Merrick Garland's career and legal work, makes a prediction in the headline of his article. The inevitable indictment of Donald Trump. It's clear to me that Merrick Garland will bring charges against Donald Trump. It's just a matter of when. After an exhaustive examination of Merrick Garland's career and legal thinking, this article ends with this. Every time he's asked about the former president, he responds, "No one is above the law." He clearly gets frustrated that his answer fails to satisfy his doubters. I believe that his indictment of Trump will prove that he means it. Leading off our discussion tonight, Andrew Weissmann, former FBI General Counsel and former Chief of the Criminal Division in the Eastern District of New York. He is Professor of Practice at NYU Law School. Also with us, Joyce Vance, former U.S. Attorney. She's a professor at the University of Alabama School of Law and an MSNBC legal analyst. She is also the co-host of the podcast Sisters in Law. Also joining us, Bradley Moss, a national security attorney with experience dealing with classified material cases. And Andrew Weissmann, let's begin with the Supreme Court filing by the Solicitor General tonight. A good half of it is about a kind of intricate issue of standing, of does the Circuit Court of Appeals have the right, have jurisdiction in this appeal the way it was brought by the Justice Department. What is your quick assessment of that aspect of the argument?
So it's very much in the weeds, but the issue is, could the 11th Circuit decide the issue of whether a special master could be appointed, or whether that was so separate from the issue they could decide, which was about the stay. And they make two arguments. They make the argument that it is one order that was issued, and so they could appeal the order. And two, that there's a doctrine of when things are inextricably intertwined. In other words, one really goes with the other, which I think is a very strong argument here. The district court actually made that argument. And so those are the sort of technical arguments, but there are a lot of other arguments. In order to prevail, Trump has to show that he would be irreparably injured if there wasn't a grant by the Supreme Court. And I think the government actually makes a really good argument that they're the ones who would be irreparably injured if highly classified information had to be disseminated, not just to the special master, but also to Donald Trump and his counsel. So I do think this is going to end up being something that, you know, when we look back, will be a tempest in a teapot, and it's not really where the action is. It seems very, very unlikely that the court would intercede, certainly while the 11th Circuit is about to hear the government's full appeal.
Joyce Vance, what's your sense of, given that the Supreme Court is now well aware that this case is not just moving in the 11th Circuit, it's moving quickly in the 11th Circuit, why would the Supreme Court bother to deal with it?
So I think that's a good question, and the court's answer will very likely be that it will defer to the 11th Circuit. This order in the 11th Circuit to expedite the case means that it will move very, very quickly. In the order expediting, the judge who signed that order indicated he had consulted with the chief judge and that they had agreed that they would put together a special panel that could quickly hear oral argument in this case after all of the briefs were filed and be ready to make a decision. The 11th Circuit signaled as strongly as it could that it was ready to go ahead quickly, certainly more quickly than the former president had requested, since he wasn't at all on board with this notion of expediting the appeal. And ultimately, that may be a factor that the Supreme Court relies on pretty heavily, saying there's no reason for us to act quickly. Trump hasn't asked for it, and the 11th Circuit is up to the job.
Bradley Moss, let's imagine for a moment that your client is Boris Epstein, and he brings you in today's New York Times. And he shows it to you and says, it turns out Christina Bobb has told the Justice Department that I told her she has to get over to Mar-a-Lago tomorrow to sign something for Donald Trump. And Evan Corcoran told her, you got to sign this thing. And she said, wait a minute, I don't know you. What kind of legal liabilities do you see in that reporting for the various Trump lawyers?
Significant liability. I mean, at a minimum, they're material fact witnesses. And we've already seen, obviously, that they're trying to interview, and they already have interviewed Christina Bobb. They're getting details about what went on behind the scenes. I mean, let's be clear. An obstruction case is being built here, more than anything having to do with willful retention of national defense information. This is going to be about lies and misleading statements to the FBI and the DOJ. And so whether Evan Corcoran, Boris Epstein, any of these individuals, you better have your own lawyer ready. You better be looking at just how much you were misled and why you gave those instructions to Christina Bobb way back in June.
Andrew Weissman, what are the follow-up questions that Christina Bobb gets, and the other directions that the prosecutors are going to want to go with these other lawyers now that they've heard from her?
There is one person right now who is on the hot seat. We can all debate Christina Bobb's conduct, and certainly young lawyers should take heed to not do what she did. But the one lawyer right now who's on the hot seat is Corcoran. And he only has one option, which is to tell the truth and to say, how is it that Christina Bobb was told to put what she put in the certification, to say that these are all the responsive documents and that a full search was done? Those are two things that we know can't possibly be true. So he has to answer both of those questions, how those got into the certification, and presumably either he told Christina Bobb that on his own, in which case he's got criminal liability, or he will pass the hot potato to Donald Trump. And, you know, if I were a betting man, I would say it's going to be Donald Trump who gave that ultimate direction that the full search was done and that all of the documents were actually in the storage bin when we know that the documents were in his office. So that's clearly the next move on the part of the Department of Justice.
And Joyce Vance, Evan Corcoran says that he personally conducted the search. That's what the New York Times is reporting, that he conducted the search himself in that storage room. And on June 3rd, this document is saying, you have everything, federal government, you have everything. If he conducted the search, he knows that the basement storage room is still filled with these documents.
Sure, he does know, and there are a lot of questions swirling around here. Going back to an earlier Trump lawyer, Alex Cannon, who in January declined to make this kind of certification and who cautioned other lawyers against searching out of concern that there might be classified material there, that none of them had the necessary clearance to view it. And so he told everyone to stay away. At least that's what the reporting is telling us. So we fast forward to this new situation where we have lawyers who say that they conduct a search, who then make certifications that don't comport with what we learn when DOJ goes in and searches. And there's a very interesting tidbit in the reporting about Christina Bobb where she says that she heard Trump say to herself and Corcoran that he wanted them to comply, give DOJ whatever they want. And so that puts the three of them squarely in a room together discussing what they're going to do. That makes the two of them material witnesses. It's interesting because these are the sort of conversations that would normally be covered by attorney-client privilege. But if she's testifying to them with DOJ or talking about them informally with DOJ, then there's some sense that that privilege has either been destroyed by conversations with third parties, maybe there's a crime fraud exception in the works, but lots of possibility here for DOJ to get information that takes it straight to the former president.
Andrew Weissman, the Atlantic article very carefully going through Merrick Garland's career and work, and what the writer was able to pick up and divine, in effect, from an interview with Merrick Garland, where Merrick Garland wasn't exactly going to turn over any cards about this, it comes to the conclusion that Merrick Garland will approve indictments of Donald Trump in this case. What was your reading of that piece?
First of all, the reporter is really exceptional. If people have been following his career and his reporting through the Mueller investigation, and now he's really been terrific. So I think, though, that there are two things I thought. One is I think he was really interesting in talking about Merrick Garland's evolution in the job, and that he was quite reticent and thinking that he really wouldn't have to deal with all of the sort of Trump aftermath, but that he really has evolved. I thought that was really an interesting observation based on his interviews with him. And I also agree with him. I think that Merrick Garland will bring this case. I think that the work still has to be done by the career people, and they have to present to him a prosecutable case. So that's still a big if, but I think that he has the backbone to go forward.
Andrew Weissman, Joyce Vance, Bradley Moss, thank you all very much for starting off our discussion tonight. And coming up, Harvard Law professor Lawrence Tribe, who was attorney. When the question is, what will the Supreme Court do? There is no one better to ask than Harvard Law professor and very successful Supreme Court practitioner, Lawrence Tribe. And when the question is, what is Attorney General Merrick Garland going to do? There is no one available to us who is better to ask than Merrick Garland's constitutional law professor, Lawrence Tribe. And so, with those two questions in mind tonight, we are joined now by Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. Thank you very much for joining us again tonight. Now that both sides have made their filings to the Supreme Court, what do you expect the Supreme Court to do in the case of Donald J. Trump versus United States of America?
Well, thanks for having me, Lawrence. Let me say that I think the panelists you had, if they were a law firm, the firm of Weissman, Vance, and Moss, would be dynamite, because they got it exactly right. The Supreme Court is really not going to do any favors to Donald Trump. His submission to the Supreme Court was very weak, and what was there was utterly pulverized, crushed by the brilliant brief by the Justice Department. Not only did the Justice Department in the Supreme Court use Donald Trump's briefing in the Court of Appeals against him, because in the Court of Appeals, he was basically saying, slow down, slow down. And in the Supreme Court, the thing he had to say was, it's an emergency, speed up. He can't have it both ways. So he's basically undermining himself, and the Solicitor General made short work of that. But there's another point, and that is she quite brilliantly structured this brief so that in ruling for the Justice Department and against Donald Trump, along the way, it is almost certain that the Supreme Court of the United States is going to make a number of statements that in the 11th Circuit are going to doom Trump's effort to hold on to the loose cannon that he managed to find to give him some relief with the special master. That is, what they will determine about the posture of the case in the Supreme Court will make it almost impossible for him to prevail in the 11th Circuit. So all the smoke will clear, and then the stage will be set for the Attorney General, who in the meantime is allowed, by virtue of the relief he already got from the 11th Circuit, which is not being appealed to the Supreme Court in that respect, he's already able to pursue an investigation using the materials marked classified. At that point, there won't be very much work left for the Justice Department to do before the ultimate decision comes to Merrick Garland and is on his desk.
Before we get to that Garland decision, is one of the options on this Supreme Court case at this point for the Supreme Court just in one sentence to just say that the Trump request is denied?
Absolutely. And that would be a perfectly normal thing to do. With an ordinary litigant, that is the most likely outcome. because he doesn't even meet the threshold requirement of showing irreparable harm. As Andy Weissman correctly pointed out, the only irreparable harm is to the United States of America and the Department of Justice in having to slow anything down and show anything to the special master. Because in an ordinary case, you wouldn't need or have a special master. You would simply have the court that ordered the warrant, issued the warrant, ordered the search. There's no claim that the search was illegal. There's no claim that the president actually did anything to declassify the documents, despite his claim that he did it by some telepathic process, a claim that he makes only out of court but not in court. So it's really quite clear that the path is open for going forward.
You've known Merrick Garland since he was one of your law students. I know you've read that Atlantic piece today predicting that Merrick Garland will decide to indict Donald Trump in this case. What is your expectation?
I do expect exactly the same thing, because to his very core, Merrick Garland believes in the rule of law. People call him an institutionalist, but he's told me, and I think he told Franklin Foer, that he doesn't use that term for himself. That sounds sort of like a bureaucrat, though in prettier clothes. But he is committed to law, to following the law where it leads, to the reality-based world as opposed to the fantasy-based world. And the law and the facts here inexorably lead to conclusions about the president having taken government documents that don't belong to him, having stored them illegally in unsafe places, having apparently attempted to use them as bargaining chips, telling the government at various points, if you want some of these things back, you want me to turn them over to the National Archives, why don't you give me some of the FBI records that are involved in my supposed dealings with Russia, transactional down to the bone. It seems to me that in these circumstances, it's clear that all three of the crimes that led to the search and seizure, the three alleged crimes, are strongly provable, including obstruction of justice. And that's not even to mention the grave crimes involving seditious conspiracy and insurrection. So the real questions before Merrick Garland are not whether to indict, but when and where and for which crimes. Where, he'll have to decide whether to indict in Washington, D.C., which, by the way, he could do even over the Mar-a-Lago offenses, because they began when he took the documents illegally from the White House in Washington, and it was institutions in Washington that he was stiffing and deceiving when he didn't return them. And when it comes to trying the case in Washington, there one could include insurrection and seditious conspiracy in addition to espionage, theft of government documents, and obstruction of justice. And the question of when depends very much on exactly when all the ducks are lined up in a row, when all of the witnesses are ready. Merrick Garland is not going to bring less than an overwhelming case. That I know by knowing him for all these years. He doesn't do things halfway. He's enormously thorough. And I'm among those who from time to time is frustrated by his thoroughness. When he was my research assistant years ago, sometimes I'd say, can't you get this done overnight? You're so brilliant. And sometimes he would take the extra 3 hours to turn in something that was absolutely over the top. This will be an indictment that is absolutely over the top, leaving no stone unturned. And I think it's important, despite the angst that will generate and the threatened violence and all the rest, that will be the beginning, I predict, of national healing, when we will begin to see that no one really is above the law, that in fact, even the president of the United States, or a former president, is accountable. And I think that will make a big difference Because it's all very nice for people to say, in theory, we're going to riot, we're going to do violent things if you follow the law. Let's just see what happens. I think Merrick Garland is not going to be put off by that.
Professor Lawrence Tribe, thank you very much for joining us again tonight.
Thank you, Lawrence.
Thank you. And coming up, Democratic candidate for Senate